Item number 1.
But what is the correction? Oh, instead of CRM, it should be CRA. We are informed that a typographical error has crept into the order detail.
Item number 2.
Actually, I cannot do alpha testing. I am earlier. Earlier, direction was given by the regarding the compliance.
My lord, I am for the petitioner and in item number 2, and this petitioner was enlarged on bail on by a coordinate bench on month of November, and co-accused also enlarged on interim bail, and on last week, bail of the co-accused, interim bail of the co-accused was confirmed by your lordship, and I am on the same footing, my lord.
What there was some direction on the last page.
No, lots of whether they have complied or not.
Oh, yes.
They have complied. I also complied.
Yes, I petitioner complied all the direction of passed by your lordship.
What is the period of custody? Prior to grant of bail, what was this period of custody?
433 days they are in
Last
custody.
was whether such custody in view of the contraband being of commercial quantity, and you are entitled to bail in spite of the bar under 37.
Yes, my lord, there is a judgment of passed by the apex court, state versus Ravi Prakash versus state of Odisha, my lord.
Here it is 3 years, not 1.5 years.
My lord, when co-accused person already enlarged on.
That, sir, we cannot cancel the bail granted to someone else. We don't want to. Therefore, we are asking you that in view of the judgment of the apex court, Ravi Prakash, you are correct, but there the period you know what it was. It was not 1.5 years.
Yes, my lord. I have another judgment, my lord. State versus Jasbinder Singh passed by the coordinate bench of Justice Shoumen Sen and Partho Sarathi Sen, Justice. There was did that.
So was the judgment. There's nobody appearing with you.
My lord.
The trial is not commenced.
No, my lord. No, my lord. Till today, charge is not framed, my lord.
How many days you said custody was how many days?
I was in custody since 433 days.
Yes, allowed.
Grateful, Your Lordship. Grateful.
Allowed.
Item number 6.
In this matter, the petitioner was enlarged from interim bail on 7th of November 2024.
All are NDPS matters. Where is the report? Where is the report?
Lordship, report has been. Presented to your Lordship. Another copy, Lordship. Lordship was filed without the yes.
How long he has stayed in custody?
When he was granted interim bail, he was in custody for 545 days. Lordship, on the last occasion. The last occasion, the state has submitted that the petitioner is not meeting the IO, he is not complying with the order of the earlier bench. Lordship, kindly see. This is the.
This is not my submission made before your lordship by the IO.
Yes.
That's why
What are you
IO
showing? What are you showing?
is called for.
This is the report that he is meeting the IO.
What is it?
This is the Hajira Khata, Lordship.
This is called Hajira Khata. That day he is not produced that Hajira
How do
Khata
you
also.
have it?
Lordship, this is with the petitioner.
No, it was not submitted by the state council. Such a situation occurred because the IU was appearing casually.
Yes, the IO,
Without
he has
having information, he
submitted
is coming to court.
on
As if
instruction
he
of
is
the
coming
IO.
for a casual visit to court. And today when a report is called for, he tenders an apology. This is the way. Unnecessary wasting the court's time, coming casually. We have seen that. He has been appearing, but he is a foreign national. That is what is going on in our mind. How to ensure that he will not flee.
He's already complying with the order, Lordship.
That we have seen, that is there. It is better that his interim bail continues for some time. We'll see how things progress, but that is the only way. I don't want to confirm it at the moment. Report has been submitted by the SI of Birpara PS. Terms and conditions imposed in the. Yes, sir. Great, next circle.
5 and 6.
Yes.
7.
On the last date, accommodation was short for on the state, as CD was not there.
Yes. What is it?
NDPS, my lord.
Quantity.
Quantity from this set is only 18 gram, 18 kg.
What do you mean this petitioner? There are recovery from trolley bags.
My lord, 3 trolley bags,
Yes.
which has been alleged that from this petitioner was recovered 18 kg.
He was carrying that bag.
No, it was in the dicky of a bus,
So therefore, how can you say that it was from this person?
as the police stated
Where is
in
that?
FIR.
Where is that? Let us see.
In one so I have got all the certified copies, my lord. This way it cannot be
This is the
frustrated.
court, it is the last day, at least he's right, he's entitled to consideration of his case, we have adjourned it once. Ask them to send you the documents, whatever you want to rely on. Someone should adhere to. I don't know what will happen. That we have understood, but the file must be here. There are so many state officers. Somebody should assist. We'll take up at the last of the bill matters. Get the file. At the end of the bill matters. At the end of the bill matters.
Eight.
Half of the petition. But in this case, charge sheet filed without FSL report. If your lordship kindly take the page number 15, para number 2, line number 3. In this case, subject to your lordship correction, I may be permitted to rely on judgments passed by the honorable coordinate bench in an identical petition.
Page 15.
Page 15, my lord, paragraph number 2, line number 3.
But in this case, not case diary is not available.
It is coming for the first time.
Next time, please.
Yes, not today.
Automatically for there.
Always something very.
What is the injury?
Injury master my instruction. Intervene civil, not severe, did not attract 26 money. There is a dispute regarding entering into the ambulance and delay squadron for this reason.
Two injuries,
Submitted. I have some lines.
two injuries is number 26 and 28. One is simple and another is.
They were stopping the ambulance.
Page number 26 and 28. Two injury report of same person, but one doctor opened previous, one doctor opened previous. Page number 26 and 28.
So benefit of doubt should go to
26.
then what is the allegation? We find that they were trying to stop some ambulance.
Entering into delays in front of the house, there is a delay squadron. This is my road.
Road for ambulance, passing of ambulance and meetings.
Delay squadron. There
And page number 28, simple injury.
Where he has sustained the injury, which part of the body? Not clear.
I.
Except traumatic. Low. Perforation membranes.
And 28, another injury.
Is only containing medical terms. What is the part of the body that he has?
some by distant go.
Not by any.
No. Hello, Pathari Bhai.
Statement of the injured also not recorded.
It has been rejected by the session judge.
Other accused person is blamed as well as signed as seal in the city.
No, madam. He did not prepare.
Others, the co-accused have been
Sandal and Gandhi.
by.
There are many accused persons. He did not, there are 4 accused. Charge sheet submitted.
Investigation completed, charge sheet also submitted.
There is no specific proceedings.
But you need to move before the session judge first.
There is no organ. Many times for a prosecuting before the first time, right? Many times the day before the session court and rejected, they come. This is not. This, it's our regular practice. There is no rules. In our area. Well, a charge sheet has been submitted, my lord. There is no like previous. Like previous. Like custodial information, only a system go. But I will cooperate with the child.
Yes. State council. There is an allegation that
Thirteen.
For the student.
was rejected.
Yes, Kashif Marshal.
This is the order of the. Why don't you annex the order?
Another act is also been lordship attached with the lordship. But when there is a case and counter this lordship, in this case lordship charge sheet has been submitted lordship.
There appears to be some specific allegation against you.
Yes.
There is a case and counter this lordship, and in this case charge sheet.
It may be, but it records that there are severe injuries. He has sustained severe. Where is it? I should see. How many occasions?
3. 2 is on bill lordship.
One, this female was granted by
Another lordship against the order lordship. The last bit.
this.
Yes. Another accused. Also bill. The 439. Plus hand.
Appears to be correct. View of the nature of injury, you should surrender and take case for conduct.
Any condition that should covered with the investigation lordship.
When the other has been granted, why you should not do that? Not the case. He is aggressive, he is the aggressor, let's see. The nature of injury, such person to be granted and this. Don't know whether his hand will ever work or not. Any veins have been ruptured, it's very deep.
Any condition lordship. Meet with the investigating lordship every week lordship. Any stringent condition
Such
lordship.
person, yes. Could be reject or you will avail the remedy of surrender count.
And not plus lordship.
The Learned Counsel for the petitioner submits that. One. As it is not today, nobody is appearing. Any such person.
I'm for the state of lawsuits. The application under section 85 and 109 of the PNS Act 2023. It is the 490 days 307 of the. The main allegation like.
You are the husband.
Main allegation Milord, and Maris Sullivan has 5 years back, they have a 3-year old child, Milord. The main allegation is the mother-in-law who has been granted bail admissible by the law enforcement. That allegation is that on 15/10/2024, mother-in-law of the de facto complainant tried to hang the de facto complaint by using own number. Knot was loosed and the de facto complainant fell from the ceiling and and because the complainant managed to escape. Is that 307 allegation?
Right of demanding more dowry, seeks of marriage, she was tortured by the petitioner and this his family. The NDPS report at page 21. Continuous ligature? Yes. Continuous ligature? No, no. I don't. But I have mentioned in paragraph 2 in the simple injuries. Within 4 years of marriage, it's impossible.
There's no mark on her neck.
Earlier, bail application was rejected by the section judge.
Mainly because of the reason of all
11.
I have added page number 51 below page 6. Because this husband-in-law, this is the reason. Mother-in-law, main allegation is the mother-in-law, she was granted. That is clear.
Altogether, there were 6 applicants.
Yes, sir.
None of them were allowed except you.
Yes.
Yes, because that I am the husband. The sole reason is that the main allegation according to the FIR, the mother-in-law, she was being the granted and main allegation the mother, she tried to kill her by using mother's hand.
Main allegation
In the mother-in-law.
against the mother-in-law in the FIR.
Yes, sir. So I have added the FIR. May I read with Bengali?
Let's try. Let's try first. If unable, that we will go.
Yes.
Here's that portion, in the middle portion.
Main allegation is that
আমাকে প্রাণে মেরে
Against
that
the
portion.
petitioner.
he's trying to kill her.
By what means? By what means?
By which is by strangulation.
No injury.
To Orna.
We are not asking whether there is injury. First, tell us what is the allegation.
On 15/10/2024, রাত আনুমানিক 8 ঘটিকায়
First, you don't give a translated copy, then you don't tell us what the allegation is. You want to
I have
proceed
paragraph
only on the basis of.
paragraph 2, Milord, I have mentioned it, paragraph 2. Main allegation is paragraph 2. I have mentioned in paragraph 2.
You have to pass the order also. Mother-in-law of the complainant tried to hang. Just place that,
Yes, Your Lord.
place it, where is this statement?
Yes, Your Lord. This portion, please.
গত ইংরেজি 15/10/2024
তারিখে
This is the main portion.
15/10/2000 তারিখে রাত আনুমানিক 8 ঘটিকায় খাওয়া দাওয়ার পরে আসামিদের আমার ঘরে ঢুকিয়ে আমার নিকট হইতে আমার মেয়েকে জোরপূর্বক কেড়ে নিয়ে যায়। আমার শাশুড়ি তখন আমাকে প্রাণে মেরে ফেলার উদ্দেশ্যে আমার আমার পরনের উন্নাতে গলায় ফাঁসি দিয়ে ও উপরে অন্যায় মানে হলো উপর the criminal অন্যায় ঝোলাতে লাগলে উন্না ফসকে যায়। আমি বাঁচতে ছটফট করি, তখন ঘরের দরজা বন্ধ করা, দরজা খুলে আমি ঘর থেকে পালাই, রাস্তায় আসলাম। Escape হলো।
Right, counsel for the standing and state house. The petitioner in bracket.
17. Have the petition.
Yes.
Lordship, one for the petition. Lordship, allegation is under section 3760. At the outset, your Lordship, I would like to draw your Lordship attention towards the order of the order of the coordinate bench of this honorable court. Lordship, kindly page number 50. Lordship, may I read? Lordship, page number 15, paragraph 3. The medical report prima facie does not advance the prosecution case to any extent. Your Lordship, then we kindly see page number 18, Your Lordship. Thus, on the ground of parity and upon considering medical report, Lordship, out of 6 co-accused persons, 5 has been granted bail by the coordinate bench of this honorable court. And I have annexed all the copies of the.
And you are not arrested even.
No, Your Lordship. But
How that
Lordship,
is
I am-
why they have all been allowed bail,
Lordship, because of
because
the.
the trial is dragging, you are not submitting to
Lordship,
the
in this
jurisdiction of the
trial-
court.
Lordship, the medical report at any cost does not support the prima facie
It's
does
a
not
different
support the
aspect,
case.
madam.
Lordship,
What is the date of FIR?
29/8/2022. Lordship, all the co-accused, I am standing on the same footing and I am paying for bail on the ground of parity. Your
You
Lordship.
should also get bail. We are also of the view, you are on the grounds of parity, you should also get bail, but
Medical,
the
Medical-
anticipatory bail is where the difficulty appears to us.
the medical examination do not support and kindly see the 164, the allegations are similar in nature along with all the co-accused persons who have been granted bail. Lordship, in a case like 376D, the medical does not support, prima facie does not support the prosecution case.
You have made it possible for all of them to get bail. By your not submitting to the jurisdiction, it is possible for them to get bail.
Lordship, kindly grant me the interim relief, I will surrender before the court court below, Your Lordship. On any stringent condition, Your Lordship.
That we are not inclined.
Lordship, but all the co-accused persons has been granted bail on the same
You are
footing that medical.
submitting for the 5th time, madam.
I apologize.
It remains the same whether you submit once or you submit 5 times. That will remain the same.
Lordship, kindly see the medical report once whether.
Let
it
us see,
supports
we'll see
this or
everything
not.
that you want us to see, but we have disclosed our intention. Yes. What is it? Where is it?
I do not-
Medical?
Kindly see.
For a change, FIR is in, so now I'll have to put it to my brother. There are 3 accused.
6 accused persons. One is before Your Lordship.
As per the What is the medical? You want us to see the medical?
Kindly sit to your lordship. My name is Abhishek.
164 what's the year book?
No, where's the medical? Which
Medical need one, your lordships. I have new, yes, it's.
After 16 days, medical.
Allegations do not support the medicals.
Medical will not support after 15.
And your
16
lordship,
days.
if we go to the FIR also, your lordship, the present petitioner is standing in a better footing because the other petitioner's name has been taken twice, the incident with them
You are
twice.
the person who has started it all. As per the allegation, it is you who has started it all. You have taken her away on 15th August and thereafter two of your friends, and then she says she fled away. She put up somewhere in the night. Next day again, 3 persons came.
Those names were, there my name is not reflected, your lordship, in the next incident. your lordship.
Obviously, you, that's why we said you started it. As per the allegation, you started it, and as per 164, you started it. And medical, you are trying to impress us with the medical. Medical has been done more than 15 days after the alleged occurrence. What will it manifest? Will not manifest.
There's, because it is an allegation of 370-60, there must be some injury supporting the prosecution case. No extent in supporting the prosecution
There
case.
is
your
no
lordship.
allegation which will be reflected as any injury. She is only saying that she was forced. That is all.
She's 26 your lordship, and the present petition is 29 years old.
Her grand counsel.
Can you protect me for a fortnight? I will surrender before the
18, my lord, I appear for the petitioner. My lord, I appear for the petitioner, my lord. My lord, 18. Am I audible, my lord?
Yes, you are.
Volume is very low.
Your voice is slightly muffled, but we can hear you.
Okay. My lord, the allegations are under section 9, 34, 39, 44, 49A, 49B of the Wildlife Protection Act. Now, the complaint, my lord, which was lodged by the range officer of Dabgram range, my lord, says that on 1st of April 1st of, sorry, my lord, 4th of January 2023 at night, my lord, they conducted a raid on house of one Krishna Das. Now, Krishna Das led them to the house of another Prabhananda Das. From the house of Prabhananda Das, one country-made single-barrel gun and a piece of antler, my lord, was recovered. Now, these two, my lord, co-accused then stated that I was the one who had provided them with the gun, and after the antler was cut, it was given to me. Now, my lord, this is from the statement of a co-accused, my lord, which has come. My name has surfaced.
The remaining piece of the antler has been given to you.
That is the what has been alleged against me, my lord, based on the statement of the other co-accused.
That has led to any recovery from you also.
No, my lord, no recovery from me.
Yes.
Page 19 and 20, the role that appears from page 19 and 20. His specific role, man. He is the supplier of arms used for poaching of wildlife. The
He
statement
has
is,
any antecedents?
yes, I'm coming to that. I'm coming to that. Warrant of arrest is pending against him since 2021, Lordship.
In this case?
Yes, madam. He's absconding since 2021, madam.
This
This
case
is
was
a 23 case.
in
This is
January
a-
23. He just now submitted on some date in January 20.
Yes, my lord. Page 8 of my petition is the written complaint.
Madam, may I take it back? I found the date in the MOU.
Kindly seize, my lord. And may I, my lord, submit what my learned friend is submitting from the written complaint, my lord. There it mentions that a warrant of arrest is pending against me, my lord. Honorable coordinate bench, my lord, has been pleased to grant anticipatory bail on to me on in that case, my lord. My learned junior is there. He will hand over the orders, my lord. Mr. Shalok Shah is there. He will hand over the orders, my lord.
He's absconding, my lord,
Which case?
in this case.
Give the name of the case, the number of the case.
Number of the case, my lord.
1002 of 22.
No.
The present case, my lord. No, the case which I am referring to.
Yes. You are number 38 DG, 2022-23, my lord.
38 DG.
Ah.
Then there is another case against you. Because
CR 37, CR 37, CR is number 37.
this is 32, in which you have been allowed.
38 DG is the present case, my lord. 38 DG is the present case, which your lordships are considering.
CR case number 37, 2023, the present case, my lord. In this case, my lord.
This is 37.
No, 38 DG is the case number. CR number is 37 of 2023. The present case which my lords are considering.
The other case saying that state council is what is the number of the other case?
Now, number of the other, my lord. That is 32, case number 32, my lord.
So in that he has already been allowed.
Yes.
He has been allowed anticipatory in that case. On 3rd February 23 itself.
Lordship. Now coming to the material against him, my lord.
This is page number 19 and 20 of this MOU. My lord, this is not a mere statement of the co-accused, this is the confession of the co-accused, my lord, under section 50, subsection 8 of the Wildlife Protection Act. The statement recorded by the Wildlife Protection Officer, Wildlife Warden Lordship, that has evidentiary value that can be used during the trial against the accused, my lord. This statement of two accused persons, they have revealed that they have obtained they have obtained the gun from this petitioner, and the petitioner is actively involved in selling the deer antlers and animal body parts in Bangladesh. He is actively involved in animal trafficking, illicit trafficking of animal body. We need him for custodial detention.
May I, my lord? No.
Yes, same nature, my lord. In the earlier case also, the statement shows that he supplied the gun, my lord.
And there I am on anticipatory bail, my lord. Sir. I've been pleased to see that.
He is actively participating. Is Bangladesh.
And regarding the evidentiary value, my lord, which my learned, sorry, my lord.
Yes.
Regarding the evidentiary value, my lord, which my learned friend has just referred to, may I request my lord, my learned junior to hand over the act. Now there, my lord, subsection 9 of section 50, my lord, clearly states any evidence recorded under clause D of section 8. Clause D is, my lord, to receive and record evidence shall be admissible in any subsequent trial before a magistrate, provided that it has been taken in the presence of the accused person. But this, my lord, from the whatever documents I have, my lord, it does not reflect that it has been taken in my presence.
While he is making his submission, he will make his submission. Yes.
My lord, I am not sure, my lord. Whatever documents I have, my submission is that it has not been taken in my presence. So therefore, my lord, section 58, subsection D is not applicable.
May I answer to this, my lord? Custodial detention. Yeah, other case also he played the same role, my lord. This is the state.
Yes, what else you are saying?
In the other case also he supplied the gun. But we need him for custodial intervention.
State Council. As per statement made by co-accused, from whom there is recovery of a single barrel gun and a piece of antler.
Deer antler.
The petitioner has been made an accused. So it is submitted by the Learned Counsel for the petitioner that the application is based only on statement of the co-accused, which also has not been recorded in compliance with the provisions of the Act. The petitioner was implicated in a similar way in another case arising out of CR case number 1002 of 22, wherein he was allowed the privilege of anticipatory bail by a coordinate bench on 3rd February 2023 in CRM within bracket Chapter 29 of 2023. The present implication is a sequel to such implications being leveled against the petitioner. The Learned State Council, on the other hand, submits that this being the second case, the involvement of the petitioner cannot be ruled out, and therefore he should not be allowed the privilege of anticipatory bail. Stop considering the permissions. The fact that the implication is based only on statement of co-accused, the statement being required to be recorded in one particular way in the Act, which apparently seems to have not been complied. the fact that he has been allowed anticipatory bail in the earlier case, as also the fact that statement of co-accused has already been recorded by the agencies. We are inclined to allow the prisoner the privilege of anticipatory.
Grateful, my lords.
Next. Charge sheet submitted. Yes.
Prosecution office report. CR cases, the office report.
What is it called? Prosecution report. Yeah. Prosecution report has been. Office report. You are. Instead of charge sheet, prosecution. Office report has been. UR has been.
The allegation undertaken. The allegation undertaken 448, 323, 355, 320, 427, 334, 534 of the Indian Penal Code and in section 350 of the Indian Penal Code. There are a long-standing civil dispute related to land between the de facto complainant and the petitioner. Because there are around 16% made accused in the present case. This is the renewal of prayer of anticipatory bail. Earlier official was turned down on the turned down on the basis of that the investigation was going on. Subsequently, the investigation has been completed and co-accused person granted anticipatory bail by the honorable court. These are changes have happened. I have come to the law. Co-accused bail may not panic before 15 now.
No, that is the medical. She was pregnant at that time, my lord, when she was sick, but my lord, I have perused 164 statement of the victim, my lord, mainly Saddam Hussein and Alia Rehman hit the stomach of the victim, my lord. It is at page number 50. These persons were present. Mainly Saddam Hussein and Alia Rehman hit in my stomach. The alleged persons knows the victim was pregnant and she was admitted in the hospital for 12 days. That is what is noted in 164 of this victim and as well as 164 of Momi.
So beside Saddam before us.
No, this petitioner's name is Lordship Motahar Ali.
But this case actually is not the favorable idea.
There are around 60%.
Early rejection is P1.
Yes, sir. At this stage, the after investigation was not completed. The eighth page number 8 meter, paragraph number 6.
What is the date of charge sheet?
The charge sheet dated 18/9/24.
Next 32. Yes.
Yeah.
Next. Not one matter. Saying next now. There are two matters. Yes. All the earlier matter. Yes.
Allegation is that 50 kg of Gaja was recovered from a dicky of a running bus. This accused, this petitioner was on that bus. He was arrested. He is the person who's bagging. It's not that it's a public bus. Many persons are traveling on that. It was recovered from the dicky. Who has put that? Who has kept that? Who has left that? No, nothing is certain. Nothing is certain. He is a boy of only 20 years old. Only in custody for 5.
But recovered from a bus on being produced by the accused person. Look, they had taken in the bus. And this is a single issue.
Here, what is the name of the accused?
Asti Pandey. Only 20 years old.
Which matter are you arguing? Accused is Swapan Das.
I took some 8 on that. Like a 8.
It was 7. It was 7 first. We find the recovery from a train and all of you are. Is from the luggage compartment of the bus.
Sir, dicky of the bus.
How it has been identified that it belongs to you?
No.
Look, they have produced it. This is the single issue. But when they were apprehended, they produced the luggages, and from those luggages, 50 kg of gaja was recovered. Now, my lord, investigation is still going on. We have received the chemical examination report, which confirms that it is gaja. Statutory period of investigation is still going on.
How many days you are in custody?
5 months, 5.5 months. Was only 20 years old. His life will be too.
The entire
He's a
sergeant
student.
was videographed.
He's a student. He's a studying in college, the document.
Prosecution verify na kori kaगज
No, if it has been stated, he is 20 years old.
What is the pass marks? What is the pass marks? It's not a, we are not making fun of you. We are trying to understand the mark sheet that we have given. It says overall grade C. He has got less than 30% in 1, 2, 3, 4, 5 subjects. Still, he has got a grade C. Which school, what is the veracity, what is the pass marks? We don't know. It is very surprising. Even if the pass mark is 33, at least
34.
you are saying 33, 34, 35, but 5 subjects he has less than 30 marks. He must be a good student who have passed with C in spite of getting less than 30 marks in 5 subjects. He has passed, he has been placed in grade C.
Maybe that's the thing, but the thing is that he's a student. He has applied for college, maybe his board is education.
Stop the. You should read it before.
I'm for the situation. In this case, madam, the only
You
ground
have a mark sheet.
I have it. Madam, only grounds is that the charge sheet has been filed after lapse of 179 days without CFSL report. That is, if your lordship can take the page number 15.
This is the recovery from the train.
Train.
Yes.
Three bags.
Yes, my lord, 24
24.4.
400 kgs of gaja exclusive possession of litigation, my lord.
24
kgs.
24.400
400 gram.
Nearly 25, nearly.
approximately.
Now, my lord, charge sheet has been filed without FSL report. Now, my lord, in this regard, my lord, I will draw his lordship kind attention about the page number 15. Line, paragraph number 2, line number 3. 50. Page number 15, paragraph number 2. Now, in this regard. Now, my lord, in this regard, my lord, I'm to draw his lordship kind attention about the observation passed by the honorable coordinate bench. The similar situation, my lord. This is the judgment passed by the honorable coordinate bench in the principalship, and this is the judgment passed by the honorable coordinate bench in the circuit bench. Both the cases, my lord, situation remains same, and his lordship were pleased to enlarge on bail because. So for the observation passed by the honorable coordinate bench is concerned, the charge sheet without FSL report is an incomplete charge sheet. And I am entitled to get the statutory right. The principal sits in the side.
Now it is two division benches.
Two division benches.
One earlier and then His Lordship Justice Banerjee.
No, there are three division benches. I have relied upon two. At first, my lord, at the principal seat,
Yes, now three.
it's now three.
After this three. Yes.
After this three.
No, this third is relying upon the earlier.
Earlier
Yes,
two judgments,
yes.
two judgments or two separate division bench.
Those orders obviously must not have been challenged.
No, till date. Till date not challenged.
And how, when the charge sheet was filed here?
My lord, charge sheet filed on the 30th December 2024. At 179 days. I have 14th and 15th are holidays. And the first instance of
So
the
179 days without FSR.
without a bill. And I have paid for bail.
I am holding the original case diary. Till date, not chemical report not yet been.
Till-
Next
till
the
date.
case diary.
And my lord, at the first instance, I have filed for the statutory bill.
This is the last page of the case diary.
And what is the custody now?
My lord, I am in custody for 191 days.
So 180 days and that's just 10 days back.
Yes.
Changes. And I am entitled, so for the subject to lawsuit correction, so for the observation part of the division, division basis, I am entitled to get the statutory bill.
180 days is not sacrosanct under this act.
My lord, so for the,
That can be extended up to one.
no, my lord,
As paid
no, my lord, no, my lord.
As paid for.
No. So for the special benches judgment of Subhash Jadhav is concerned, only on the ground of non-receipt of chemical report, it is not a ground for extension.
Ah.
That has been also been observed by the
That's-
judgment of the Idul Mia case
No.
in Subhash Jadhav.
That's true, that's true.
That is the judgment. I can revise the judgment. I was also party of that case that case. But the page number two, my lord, can you see the judgment passed by the CRM NDPS 1359? Paragraph number 2.
Subhash Yadav.
Subhash Jadhav. There is a three judges bench judgment.
What is it? We can't make out from reading this.
Why not give me 5 minutes passover? I will correct that. I will print out that I have the judgment.
That judgment says, my lord, so far my knowledge goes, the receipt of the chemical examination report is not a ground to extend the period of 180 days more. 12 cases were decided together. In that case, my lord.
Go before the next bench. Maybe I'm not going. Can we have a copy of this? One of these.
My lord, I have.
This one.
My lord.
Want to see the view of the
Hello.
content benches.
My lord, my lord.
See the.
Twenty-two,
Next.
23, 24, 25, 26, 27, 28,
My lords, in item number 28. My lords, in item number 28, I am appealing for the petitioner, appellant. I pray for next circuit, my lords.
That's great next.
Grateful, my lord.
29, 30,
Lordship, yes, that's great next.
31, 32,
I'm for the petitioner in item number 32, my lord.
Yes.
Online.
Yes.
My lord, this case was regarding that where I challenged the jurisdiction of the assessing officer in issuing the notice under section 148 of Income Tax Act. My lord, a large step, my lord, my lord, you were pleased to consider the case law of the ex-aware judgment.
Aware, yes.
My lord, where the notices were the notices issued under section 148 was quashed. My lord, saying that the jurisdictional assessing officer has no jurisdiction in issuing such notices. My lord, if I may please, please the lordship to submit.
Yes.
My lord, if I may please to submit one more judgment of the Bombay High Court, where even the order under section 148 AD was held to be bad in law of Sundara Multipack. My lord, learned friend will pass over the copy of the order. My lord, in this matter, Hexaware was referred the Bombay High Court judgment. My lord, if I may please come to point paragraph number 5. The internal page number is 123. Paragraph number 5. My lord, here even the order passed under 140.
Lordship, am I audible?
Yes.
My lord, would my learned friend once again repeat the judgment that he is referring to, your lordships?
This is the judgment of Bombay High Court in Sundara Multipap Limited, 164 taxman.com 608 Bombay.
Thank you, thank you. Grateful, my lords.
My lord, may I please read the judgment, my lord, the relevant paragraph?
Paragraph 5, we are going to paragraph.
Yes, ma'am.
It is also relying on Hexaware.
Yes, my lord. Here, Hexaware has already quashed the order. It quashed the notice under section 148. My lord, this judgment has taken a step forward and said that even the order passed under 148 AD is bad in law. It should be done in a faceless manner.
Here the notices are issued under which provisions in this present?
My lord, 148 AD is the order passed by the assessing officer, and 148 is the notice issued by the assessing officer.
On both these stages, Hexaware is very clear.
Yes, my lord. The Hexaware says that jurisdictional officer cannot pass an order.
Faceless assessment.
Yes, my lord. My lord.
It has to be faceless assessment.
Yes, my lord. It has to be issued by the faceless assessment officer.
So it is, according to you, it is in contravention of the now procedure prescribed by a notification issued under section 151.
Yes, my lord. 151A.
151. The same point is there in issue. File your opposition.
Yes, my lord. I'm sorry.
You are asking the learned DSG to file the opposition.
Lordship.
But in the meantime, don't proceed against.
My lord, may I just have your lordship's attention for one moment, if your lordship so pleases?
Yes, you may.
My lord, am I audible, I guess?
Yes, loud and clear.
Thank you, lordship. Lordship, only two things that I indicated at the onset of the hearing was this Hexaware judgment is now under scrutiny of the Honorable Apex Court.
We understood that you said yesterday.
Yes, my lord. And my lord, my learned friend is referring to a judgment of the Honorable Bombay High Court, which is some 1,000 kilometers away. Our own circuit bench has decided matter. Honorable Justice Chanda has dismissed it on the same point.
You want us to rely on the order passed by the single judge?
No, my lord, I'm just referring to it. But since your lordship has indicated I should come up with an reply, my lord grants me a reasonable time to file reply. I will annex whatever documents I have to annex there.
It is very much available to you that order passed by another high court, whether it has any precedential value or not. Where is it gone? Disconnected.
No, my lord, I'm there.
No.
Yes, learned DSG has been discussed.
Paragraph in Hexaware,
My lord,
which is the relevant paragraph in Hexaware.
my lord, paragraph number 34 onwards. Page number one. I just add this. Page number 69 of the CAN application. Paragraph number 35.
My lord, I suddenly got disconnected. Am I audible now?
You are audible, you are correct. You see this, please, normally the such a plea is available that whether the order passed by another division bench in another high court would have
No,
precedential.
my lord, as your lordship indicated, we will file an objection, and in the meantime, you are not proceeding with that proceedings.
Correct.
But
So-
my lord, only my humble submission would be, my lord may not reflect that in the order.
My lord, a stay has to be given because they are proceeding. They have issued me a 142-1. They have issued me a secondary 142-1 and a notice.
Then, my lord, he should go before the Honorable Apex Court.
The short issue raised by the learned counsel for the petitioner is that he has been served with a notice under section 148 based on an order passed under section 148 capital A within brackets small d of the Income Tax Act by the jurisdictional assessing officer. It is submitted that the action is in contravention of the circular dated. What is the date of the circular?
29th March 2022, page number 23 of the CAN application.
23. The circular dated so and so issued in exercise of statutory powers under section 1 and 2 of section 151 A of the Income Tax Act, having a statutory force. So it is submitted that the learned counsel for the petitioner relies upon decisions of the Bombay High Court in the case of Hexaware Technologies Limited versus Assistant Commissioner of Income Tax, reported in 2024, 162 taxman.com, 2025 Bombay. As also other decisions of the High Court Andhra Pradesh and the Bombay High Court.
My lord, our principal High Court and the principal bench by the Chief Justice,
Submission is, it is further
There's an
submitted.
interim order by the Chief Justice.
The decisions, the division bench of the Honorable the Chief Justice has also directed and has also granted interim relief to the appellants in MAT 1690 of 2023 under an order dated 25/9/2023. So the said interim order is continuing till date. So the learned ESG I submits that the issue that the decision of the Bombay High Court being relied upon by the learned counsel for the petitioner has been taken up in appeal by the department. He, however, is not in a position to inform the court that any order has been passed.
Lordship, may I, my lord? On 29/11/2024, the Honorable Apex Court has been pleased to issue notice upon the respondents and tag the diary number of this disposing the conversion delay, and has been pleased to tag it together with SLP number 27738 of 2023.
Didn't say anything yesterday you were appearing.
Lordship?
Yesterday you were appearing, you did not inform us anything that apart from filing before the Apex Court, anything other.
My lord, I had indicated the number. Your lordship expressed that right now we don't need it.
What is the order? Show us the order. Where is the
My
order?
lord, we'll file it. It is only condonation of delay has been granted and the SLP has been admitted. That's all.
So there is no order right now staying there. Decision.
No, my lord. There is no order of stay. There is no order of stay.
Stay order.
There is no order of stay.
Passed by the Apex Court in the SLP filed on behalf of the department. Considering the aforesaid facts, the legal position as emanating from the decision of division bench of two other high courts, as well as the decision, as well as the interim order granted in the case of Divnath Dey in MAT 1690 of 2023 by a coordinate bench of this court, the jurisdictional issue being involved, it is, we consider it appropriate that the respondent be given an opportunity to file their affidavit in opposition so that the matter may be considered. Stop. How much time, why, when can you file it?
My lord, we will need by the opening 1 week after the reopening.
The SGI submits that they would require at least a week after the court's reopening for filing the affidavit in opposition. So let the matter be listed on.
My lord, 1 week at least may be given to file any rejoinder if necessary.
Please allow us, you can make your submission after the order is dictated, after every line you make a submission.
Deeply obliged.
From 17, so at the time in the meanwhile, may be utilized by the appellant's counsel to file a reply if required. So we further direct that the department shall not take any further action pursuant to the Which are the two orders? Date, give the date.
My lord, the dates are, the pages are, my lord, in the notice is under page number 33 of the CAN application. The date is 15th March 2024.
Based on the notice dated 15/3/2024. And
My lord,
Page 77, dated
page 77
77, that is the 142 notice.
and the notice dated 17/10/24 issued under section 142, 1 of the Income Tax Act.
Lordship, one but indulgence, my lord. My lord, I just recollected, I sorry because I could not, the order that was passed by the learned single judge dismissing the writ application was further upheld by this honorable court in a division bench appeal. I think Mr. Singhania, before your lordship, perhaps has the copy of the said division bench order.
Yes, everything it will be coming up on 17. So you have
Lordship.
granted stay till 20.
Lordship. Lordship.
Other one.
With your leave, my lord.
Yes.